Okay, well, my clock says it's noon, so we'll start, and we've got about 50 people on the Zoom call, which is kind of fun. Sure wish I could see you all, but this is a version of Zoom that doesn't allow that. So first, let me say thank you for joining us. We didn't know whether we'd get a big response or not. I know lots of people are doing these sessions, and there's lots of competition out there for your time. So I appreciate you sharing your time with us. I want to begin by acknowledging the land. As many of us are settlers on this land, we pay respect to and recognize that the land that I'm on here in Toronto is the land of the Ojibwe, the Anishinaabe, and in particular the Mississaugas of the New Credit. This territory is covered by the Upper Canada Treaties. I think the recognition of the history, contributions, and importance of Indigenous peoples must be connected to our collective commitment to make the promises and the challenges of truth and reconciliation real in our communities. And for those of us who are living and working in the housing sector, I think there's a special obligation on us, as so many of our communities are really built on the issues of inclusion and diversity. So thank you for letting me say a few words about that. I'll also let you know that I use the pronouns she, her, and hers, and I think that's another important statement that we should all be making when we do presentations and at meetings. So as you are all now familiar with using Zoom, I probably don't need to tell you that there is a chat feature. If you want to pose a question, please use that. I'm not going to look at that until I get to the end, and I will leave a few minutes at the end for answering your questions. Everyone's muted, so you can't speak to me live, which is unfortunate, but we do have quite a number of people on the call, so it wouldn't work otherwise. So let's dive in. Of course, we're living in extraordinary times, and these times have particular impacts, I think, on communities. And I know we've been getting many calls from communities that we provide legal advice to, mostly co-ops and nonprofit housing, where tempers are fraying a bit, and people's otherwise good humor might have slipped a bit with all of the stress of the times. Of course, that's made worse by the fact that we're all at home together, and home in communities means everyone's, possibly under a common roof, or at least in a common community, which can lead to some other issues. So what does this mean in housing? Well, I'm not able to, there we are. Sorry about that. It means that we, as housing providers, of course, the first thing many of you did was make some adjustments to accommodate physical distancing, that 6 foot minimum that we're all asked to maintain between us. And of course, when you're in a group setting where you share lobby, elevator, laundry room, hallways, external doors, and that sort of thing, you need to make some adjustments. And while I'm not going to spend a lot of time focusing on that today, I would suggest that you join my colleague Claudia Pedrero in a couple of weeks, because she's going to talk about more operational issues, the relationship of COVID to housing providers and their operations. And of course, the second point is neighbors might need to minimize contact with one another. That's some of that will be dealt with in Claudia's presentation, and some of that I think sort of relates to what I'm going to talk about today. But my third point, people who suffered from mental health disabilities before COVID-19 may have worse symptoms now, and people who for whom mental health has not typically been an issue may be starting to feel some symptoms of anxiety or depression, just simply from the isolation that we are all experiencing. And so I think We owe a bit of a duty to each other to be a bit more tolerant of that and recognize that people's behavior may have changed as a result of these very difficult circumstances that we're experiencing. And I think also we need to recognize that we'll need some outside supports in order to get through in some cases. So I thought about those things, and in light of the various calls that I've been getting about those things, I thought, no, a quick hour-long webinar on this to let folks know that what they're experiencing, first of all, is what others in the sector are experiencing, but also to review some of the basic responsibilities of housing providers under the acts that we have, some of the tools that we've always used to resolve conflicts and how they might work now. And then talking a bit about the future, which of course we know very little about, concretely, but we can imagine some of the consequences of lifting some of the restrictions that we currently face. So with that in mind, I'm going to spend a bit of time on the Human Rights Code. I'm going to touch a bit on how the Residential Tenancies Act has been affected by this, Occupational Health and Safety Act, to the extent that it relates to the community aspect of housing. I know that a lot more can be said about this plus other employment law issues. And my colleague, Celia will be addressing employment law and COVID at next week's webinar, same time, next Wednesday. And this should take me more or less through until 12 o'clock today, with a bit of time for questions at the end. So just a reminder that today's webinar is providing legal information, but not legal advice. I know there are many on the call today, or on the teleconference, video conference rather, who are already clients of ours and have been calling for legal advice on issues related to this. But if you are with an organization that's not a client of ours, but you would like legal advice, then by all means contact me after this presentation, and we can get you set up and get the advice that you need, assuming it's something that we act, that's an area that we act in. So let's start with a very quick refresher of some of the human rights obligations that we have as housing providers under the Human Rights Code. So in Ontario, and I don't believe there are people on the line from outside of Ontario, but if there are, please note that everything I'm saying relates primarily to Ontario, and to the extent that some of the principles apply elsewhere, you'll need to figure that out on your own. So in Ontario, we have something called the Human Rights Code, and it takes priority over all other pieces of legislation in the province. So all of the housing providers are covered by the Residential Tenancies Act. Co-ops, of course, also are under the Cooperative Corporations Act, and there are many, many other acts that apply to housing providers. But all of those get trumped by the Human Rights Code. We consider it quasi-constitutional legislation in Ontario. But of course, co-ops especially, and other housing providers to a lesser degree, also have internal documents that govern how communities operate, how people within those communities relate to one another. And so in co-ops, that's bylaws and occupancy agreements. In nonprofit housing, you have leases. And those internal documents, of course, always take a back seat to requirements that are in provincial legislation. And then, as I've already said, those take a back seat to the Human Rights Code. So clearly the Human Rights Code takes priority over your internal documents as well. And then at the bottom, we have something that I call personal preference, which is just each individual's idea of how the world should operate. And that, of course, is at the bottom of the pyramid, because it is trumped by everything else. So that gives you a sense of how important human rights are within the housing context. And of course, just to review, this is the list of characteristics or grounds, as we call them in the human rights context, that are protected by the Human Rights Code. And you know, the one that probably comes up most frequently is disability, and it includes mental health disability as well as physical disabilities and addiction too. And mental health and addiction are things, of course, that might be affected by COVID-19, and hence my interest in addressing issues of human rights in this presentation. So, Human Rights Code requires that housing providers accommodate these protected grounds or characteristics, including disability. And what does that accommodation really mean? Well, I like to think of it as providing something for one person that others do not get, so that that person needing accommodation has a similar housing experience as others have. And certainly we can imagine that if someone, for example, needs some changes made to their washroom, grab bars, and so on, so that they can easily use the washroom, the toilet, the shower, and the sink in the same way that others do, then they might make a request to their housing provider to have those things put in place. And I think that's the kind of accommodation that most housing providers are really familiar with. This requirement has been around for quite a long time, and that's a really simple example of accommodation. But if we look at this very fun graphic that the Interaction Institute for Social Change has provided us, we see that not everyone is going to need the same accommodation. So in the image on the left, we see what equality looks like. Equality meaning sameness. So in this scenario, there are 3 people who are attempting to watch the game without playing. And in a pre-COVID world, it would not have been unusual to see all those people on the other side of the image, but now it sort of horrifies me to think. But anyway, we'll one day be doing that kind of thing again. These 3 fellows, in fact, have decided not to pay, but rather to watch over the fence. And you can see that by giving them each the same accommodation, so 1 box to stand on, the fellow on the left didn't need a box at all, and so now he's just seeing from an even higher vantage point. The fellow in the middle has accomplished the goal of seeing, and the fellow on the right is still in the dark, can't see the game. So if we reorganize the boxes to allow the guy on the right to see, everyone can in fact have the similar experience of watching the game. So that's the equity approach, right? And that means that not everyone is getting the same thing. And that's what accommodation can result in. So one day I'll come up with a graphic that shows something to do with housing in a similar way, but I think the principle here is a good one and will be obvious to you. So is it everything that a requester wants? Well, not necessarily. I mean, if we look back here, you know, these people may also have wanted a table beside them to put their cans of Coke, but they didn't get that because that didn't relate to their ability to enjoy the game. So the accommodation is, the requirement rather, is to accommodate with appropriate accommodation. And so in the case that we've just looked at, they needed enough height to see over, and that was achieved. And often that appropriate accommodation is determined based on some kind of document from a medical professional, for example. So, you know, in the case of grab bars in the bathroom, a housing provider being asked for that might say, well, actually, we'd like to understand from your occupational therapist or someone else who knows your situation well, what it is exactly that you are having difficulty with and how we can change that right now, with what methods. So that's an appropriate accommodation. And so the other aspect of it is, to what extent does a housing provider have to provide accommodation? Well, they have to do so to the point of undue hardship. Undue hardship is a very high threshold. A housing provider can consider only two things when determining if something, if an appropriate accommodation is going to constitute an undue hardship. They can look at the cost, and if the accommodation isn't going to break them financially, then essentially they're on the hook for doing it. Now, part of that analysis is looking for pots of money that might be available from other organizations to help pay for these things, March of Dimes, or other nonprofits and charities out there who work in this field. And then the second aspect is, if an accommodation, an appropriate accommodation, would end up causing a health and safety risk to either the person who's requesting the accommodation or to somebody else, then that might also be considered undue hardship, and therefore the housing provider wouldn't have to do it, to undertake the accommodation. So that's all pretty straightforward, and for those who've been to human rights presentations I've done in the past, you will know that I've said nothing that I wouldn't have normally said. So what the heck does COVID have to do with this? Well, first I want to let you know that on April 2nd, the Ontario Human Rights Commission, OHRC is the short form, released a policy statement on the COVID-19 pandemic. And I've given you the link there. And I know that this presentation will be available afterwards to view, so you can go back and click on that link and have a look at this policy statement. But the Ontario Human Rights Commission were basically saying that they were recognizing that the most vulnerable groups in Canadian society are disproportionately negatively affected by the COVID-19 pandemic. And I think we all know that from our own personal experience. People whose employment, for example, might already have been marginal or unstable. Many of those people were among the first to lose their jobs when the state of emergency was called, and so on. We know as well that it's harder for people who are in long-term care or who are homeless or who have other precarious housing situations. It's harder for them to social distance, achieve that physical distance that we've been asked to do. So what did the OHRC say about that vulnerability? Well, they provided us with half a dozen principles for having a human rights-based approach to managing the COVID-19 pandemic. And again, you can go and look at this policy afterwards, but some of these don't obviously relate to housing. The first principle is to approach and prevent treating COVID-19 as a human rights obligation. Your role in preventing and treating COVID-19 is limited. Obviously, you have no treatment role at all as housing providers. Perhaps a prevention role insofar as you need to create an environment where passing on the virus would be limited. The second principle that they give us is that they ask us to respect the rights of First Nations, Métis, and Inuit, or collectively Indigenous peoples, through measures that you might take regarding COVID-19. Set strict limits on measures that infringe rights. That's the third principle they offer. Again, that might mean that you are providing different accommodations, different systems of using the laundry room, for example, for people who are more vulnerable than others, and that vulnerability might be connected to the Human Rights Code. The fourth principle they give us is to protect, is a mandate to actively protect vulnerable groups. And again, that might mean that you are providing different kinds of COVID-19 protection measures in your housing organization with a view to protecting more vulnerable people. The fifth principle rather is to respond to racism, ageism, ableism, and other forms of discrimination. As you would at any time, you would be responding to those things. I think there is a possibility that, as I alluded to at the beginning, with people being having a little more frayed tempers and so on, some of these things might be uncovered more easily in people, and therefore as housing providers you have obligations to manage that. And then the sixth principle that the Human Rights Commission have given us is an obligation to strengthen human rights accountability and oversight. And I think that's a more, that's at a higher level than an individual housing provider might feel they're at. But so it's important, nevertheless, to consider that if the Human Rights Commission felt that this was sufficiently important to issue a policy statement on very short notice, then you can be sure that issues around human rights in your housing situation should also achieve that level of dominance. So what does it actually mean in housing? How does COVID-19 affect human rights in housing? Well, I've already talked about how we might have different behaviors within the community that would require the kinds of accommodations that you are expected to provide. We also know that some of the ways in which we might try to resolve human rights issues might have stalled because of the pandemic. So the Human Rights Tribunal of Ontario, I can tell you that they are not conducting hearings in person. They are conducting some hearings and mediations by phone or in writing, but as many of you will know, they were already quite badly backed up. And so a lot of the formal ways that people might have to resolve human rights issues are going to be even further delayed as a result of the pandemic. They are accepting new applications, and they have suspended typically, as some of you will know, if let's say you felt your human rights have been violated today, you would have a year from today in order to file an application at the Human Rights Tribunal. That 1 year limitation period, as we call it, has been suspended during the COVID emergency order. The Human Rights Legal Support Centre, which is another body of the Ontario government, which might help people as they struggle with determining whether their human rights have been violated. They are obviously closed for physical, like the physical office is closed, as most offices are. But they are still staffing their intake lines and have staff working remotely. So folks who feel they might need some support legally through that body could still get access to that. And then another organization that some of you will be familiar with, the Center for Equality, Rights and Accommodation, is also, as you might imagine, closed to walk-in support. But they are working their usual hours assisting tenants and co-op members with questions about eviction, human rights, and issues related to COVID-19. And if you go to their website, you could get information about how to get access to that. So there is a recognition by all of these bodies that, just as there was with the Human Rights Commission issuing their policy statement, that issues of human rights might be at the forefront during this period. So that's about all I want to say about human rights related issues. I want to touch briefly on the Residential Tenancies Act, because I know that many of you will know some of this. Some of this might be news to you. but I know because of the calls that I get that the behavior that might lend itself to a discussion about eviction at the landlord and tenant board is certainly ongoing, and in some cases getting worse for the reasons that I've previously mentioned. So the landlord and tenant board is accepting applications. So if landlords or co-ops are at the stage where they've fulfilled all the conditions for filing an application, and they can file that application still. And in fact, we have done that for a few clients during this period. But the landlord and tenant board is not having hearings or issuing orders, except under very, very, very unusual situations. And they have a new form that they've created for landlords or co-ops to request an urgent hearing, which would be conducted, of course, by phone. And the standard is very high. It's difficult to conduct a hearing by phone anyway, so I think their limitation on doing so is wise. They haven't set up a video conference system that I'm aware of, which might help a little bit because it's easier somehow when you can see the other parties. But I know that the standard is high because we've been rejected, I think, 3 times on applying, and we have not yet found a case that they considered to be urgent enough to proceed. Even if you were to get an order from the landlord and tenant board on an urgent hearing, the sheriff doesn't have the power right now to enforce on the basis of a landlord and tenant board order. You would have to go, your lawyer would have to go to Superior Court to request to have that, to have a different kind of order issued ordering the sheriff to evict. And of course, the Superior Court is also not meeting because for the same reasons. They don't want to be part of the spread of the pandemic. And so it's very difficult to get them to act on an urgent matter. And so you can see that using the landlord and tenant board as a way to resolve a community conflict or a community dispute or situation right now is almost impossible. So I will also point out that they were already very much backed up. They had a backlog because they had a number of vacancies of decision makers at the landlord and tenant board, and they got behind on their list. And so, of course, having this break in hearings isn't going to help. And so the backlog will be even greater. And of course, we also know that there will be a whole slew of economic evictions that will result from co-op members or tenants who fail to pay their housing charge or rent. So that's a nice segue to this slide, which is about that very issue. So I know there's been a lot of discussion about this in the news, about whether there should be support for landlords that would allow them to then waive rent or housing charges, but there has been no such policy. So landlords and co-ops do not have the legal wiggle room to waive rent or housing charge. Obviously, they can make that decision on a case-by-case basis. But they will not be compensated centrally by the government in cases when they don't receive rent or housing charge. So if they make a deal with their tenant or their co-op member to pay later or to waive payment for a period of time, that's a private deal. And of course, we have a problem because many tenants and co-op members are living on less income now. Now, in the co-op housing and nonprofit housing world, there are also many tenants and co-op members whose source of income has not been affected by this because they live on social assistance. So it's the market people in the housing world who might be affected by this. So many landlords and co-ops are entering into repayment plans with their members and tenants that would defer rents and housing charges to another time. And then frankly, many are serving N4s or N4Cs, which is the N4C, of course, would be after a notice to appear in the co-op context. Many, though, are choosing to be in a position to file their application at the Landlord and Tenant Board now and have their hearing heard at some future date, assuming that the arrears are still there. I should also tell you that some other providers I know have made policy decisions. Some have said, no, we're not doing notices to appear, we're not doing N4s during this period. And that, they're making that decision kind of based on the signals that we're getting provincially and from, and I suppose from the Human Rights Commission policy as well, to keep an eye on the most vulnerable, and starting an eviction process during COVID-19 might be seen as sort of a drastic step to take. I'm also aware of at least one of our clients, which was in the fortunate position to waive all of the housing charges for the month of April. They did so, the board made that decision without talking to us, and we were told as by the by, they just let us know in the context of another discussion. And so certainly housing providers are taking a wide range of approaches on this issue. So that's all I really wanted to say about managing community through COVID as it relates to the Residential Tenancies Act. I want to touch very quickly on the Occupational Health and Safety Act, which, as I mentioned, it'll be dealt with in the context of Sophia's webinar, which is in a week's time. But there are a couple of issues that I just thought I would highlight for you that relate to the community issues that might arise through COVID-19. So, as I know you're aware, occupational health and safety legislation in Ontario has requirements to protect staff from workplace harassment and workplace violence. And just to remind you, workplace harassment is a course of vexatious comments or conduct known or ought to be known as unwelcome. And violence is an exercise of physical control that causes or could cause physical injury, or a threat of something that might cause physical injury. So under occupational health and safety, and I apologize to the nonprofits in the room on the call, I've got co-op staff, I should say housing provider staff, because this relates to our nonprofits as well. Staff have the right to be protected from these things by their employer, and the employers are the co-op and nonprofit boards. So you need to keep an eye on whether the behavior that is resulting from the COVID-19 pandemic, the anxiety and depression and feelings of isolation and so on, has the potential to lead to harassment of staff. It's a little bit more difficult to harass when you can't pop into the office, I think, although certainly we have many electronic ways of communicating now which might have the same result. So not only is it more difficult to know when it's happening, but it might be more difficult to put an end to it or put in place protections that would make it more difficult for people to harass the staff. But know that as housing providers, these obligations to protect your staff are ongoing, irrespective of the COVID-19 pandemic. I'm going to just take a look. I saw that there were a couple of questions, and I want to just see, oh, they're not popping up. Well, I'll figure that out later. Let me have a look here. I've been asked what types of things we have tried to consider urgent for the purposes of eviction. Good question. One I know was a case where we were acting for a housing co-op that wanted a declaration that a unit had been abandoned. And while often housing providers will make a decision that a unit has been abandoned and simply change the locks, this one had some, there were some reasons that made that difficult. And so at the co-op's instruction, we applied for that declaration just before the pandemic was declared. We made a case that given the pandemic and given the housing shortage generally, and given the fairly clear evidence that the person who had been occupying that unit was not going to return, that the landlord and tenant board should proceed with that hearing regardless, and we would do it by phone. They said no. Another case, I believe, and it's not one that I've handled personally, but I believe it was involving some fairly bad behavior, criminal type behavior and drug dealing, but I don't have the details, so I can't tell you exactly how bad it was. But given that even you know, the issue of dealing and so on was not enough to get the landlord and tenant board's attention, so I'm not really sure what the standard is and what they're looking for. Okay, so let me move on. Why is this not letting me move on? There we are. So a couple of words on some of the tools that we use typically to resolve community conflict, which I think many of these can still be applied in the context of COVID-19. So many of you, especially in the co-op world, will know what I mean by a performance agreement. In the nonprofit world, often this is, we call this a behavior agreement. And so there is no reason why you still can't enter into performance or behavior agreements with people to try to smooth out the edges of behavior during this time. Having the conversation with the tenant or the co-op member that leads to the performance agreement can often be a valuable one, because it helps the parties understand what the basis of the behavior might be, and it also helps establish some expectations on all sides. Tolerance, I think, is an enormous tool right now to resolve conflict. We are all struggling, and we need to recognize that some will be acting in different ways than they would typically act because of the stress that they feel, whether it's economic or social isolation, or, you know, all of the other, you know, worry about catching the virus, fear that someone they love who has the virus might die, and so on. We are all under an enormous amount of stress. I know that another tool that we often use, and we can still use, is to get support from the sector more generally. In the co-op context, of course, CHF Canada and the local federations, but ONFA and other housing organizations in the nonprofit world are still very much working. They're just working differently. Community mediation is always a good idea to resolve some of these community problems or issues. And here in Toronto, we have an organization called St. Stephen's Community Mediation. I know there are similar mediation organizations that deal with community disputes in other parts of Ontario, and they can be excellent ways to smooth out the edges of some of these issues that continually come up. Weirdly, I don't know why, but people often take notice when they get a lawyer's letter. So it's not unusual for us to be asked to write a letter on behalf of a housing provider to try to rein in the behavior of a tenant or a co-op member. And certainly, you know, that continues despite COVID-19. Then I think even though right now COVID-19, as I've already said, is kind of stopped any ability to evict, it doesn't mean that on these complex behavioral cases, which frankly, many of which predate the COVID-19 pandemic, it doesn't mean you can't continue to build the file, if you like, that would ultimately lead to a possible eviction application. And so collecting detailed written complaints, pardon me, being sure you get complainant's consent and so on, are all important things that the tools rather, that we use in non-COVID times. And I see no reason why you can't use all of these things during COVID-19. So I've confirmed with St. Stephen's Community Mediation that they are now conducting mediation online. It would be a very different way of trying to mediate, but I think we're all getting increasingly used to using the tools necessary to communicate and make decisions with webinar and video conference. So there's no reason a mediation couldn't happen that way as well. The conversations that I referred to, well, obviously we're much more accustomed to having those behavioral conversations with tenants and co-op members in person. There's no reason they can't now be done by phone or video conference. I've participated in a few of those already in the last 8 weeks, and I anticipate there'll be many more in the future. And then getting the support that you need, again, it's still all available. You just have to use different means to get it. And certainly the organizations that support housing are all still very much working and ready to provide that support. So what's next? Who the heck knows? One day we'll return to something that looks more normal than we do now. But I don't really know, just like anyone else, I don't know what that's going to look like. The measures that you are currently using and have historically used to manage behavior might continue to look different for a long time. So, you know, it might be the case that that we are having video conference notice to appear meetings in the co-op sector for many, many months and perhaps even longer. Or it may be that we will have landlord and tenant board eviction hearings or eviction mediations at the landlord and tenant board, and maybe that we have those by video conference in the future. But the legislation hasn't changed. Your obligations as housing providers under the Human Rights Code, the Residential Tenancies Act, and the Occupational Health and Safety Act haven't changed. We need to find new ways to meet those obligations. And I think, as I've already suggested, some of the bodies that we use to try to manage these things, the Landlord and Tenant Board and the Human Rights Tribunal, when they are up and running, are going to be hugely backlogged, and it's going to create an even bigger, it's going to promote internal resolution to issues even more so. So I think, you know, the performance agreement, the stern chat, the lawyer's letter, and so on, are going to need to be employed on a more regular basis, because we won't have these external bodies up and running and processing files for quite a while, is my guess. I think, and it's not on my slide, but I think one other thing that that might result in the return to normal stage is that there will be some personal bankruptcies and so on. People are going to make decisions about their finances that result from this pandemic. The fourth in our series of webinars is my colleague Michael Hackle and a person whose name I've forgotten, Angela Pollard, who's a licensed insolvency trustee, will be doing a presentation like this in 3 weeks' time on the issue of bankruptcy, and it will be primarily pitched to organizations that are contemplating, or businesses that are contemplating bankruptcy. But it may be worthwhile for folks who want to understand how it might work in the personal context to also attend that session. So we do have about 15 minutes left. I want to point you in the direction of a number of other resources, many of which you will know about. The housing organizations, of course, both have websites devoted to the COVID-19. Every lawyer has something on their website about COVID-19. We're blogging about it regularly. The various human rights bodies in Ontario and federally, and then CIRA as well, they all have stuff about COVID-19. A number of our clients have come to us with issues of behavior which are clearly linked to the anxiety and depression and isolation and so on that people are experiencing. And so one of the things we've recommended in those cases is that housing providers actually send notices to their tenants or co-op members identifying where they might find mental health services in the local area or online. And these are some suggestions of you know, some of the more robust websites. I know CAMH is doing a great job of helping people through this and providing actually a lot of support through one-on-one and group counseling online as well. So I think other than questions, I just want to remind you about our upcoming presentations. These are all colleagues of ours here at the firm, except the last session is co-presented with an insolvency trustee. And so if you haven't already registered for those, you may consider doing so. And now I'm going to try to pull up now, for reasons unknown, I cannot open the Q&A block. So if you want to put your questions into the chat block, that would be great. Okay, so Patricia Johnson has asked, any suggestions on how people wanting mental health assistance communicate with those agencies when they do not have online access? Well, that is a tricky question. I guess, you know, we are more and more leaving our friends and family without online access kind of high and dry through this, because so much of what we do is online now. So I don't know if other providers have figured out a solution to this. I know For example, my mother doesn't have her own computer, but she lives in a retirement residence and they share a computer. And I've asked her whether she's worried about touching a computer that others use, and she assures me that it gets cleaned regularly. So it may be that in some of your facilities, you have common rooms that you're still allowing people to use, and you might have a shared computer for that purpose. I don't know. I mean, there of course are risks in doing so. People can no longer go to the library though, or use other shared computer situations. So it may be worth thinking about how you can provide access to others in your co-op or your housing provider. A number of you have asked me whether the slides will be available. The presentation actually is being recorded, and Fraser Page, our IT and communications manager, will be posting it on our website. We have an education tab on our website now, and there are a few other webinars that we've done that you may want to take a look at, and this one will be up. Jackie Rickards has asked, can you still issue an N5 notice for ongoing disturbances? There's no prohibition on issuing a notice, and in fact, you can file an application at the LTB. It's just that the LTB isn't going to do anything with it when you get there. So if behavior is such that you feel an N5 is necessary and you feel that you've explored any human rights related reason for that behavior sufficiently, then I see no reason why you couldn't use an N5 as a way to try to moderate the behavior. Candice Salverda has asked, we are currently working on our budget for next fiscal year. Is there any legislation that's been acted that prevents us from increasing our housing charge? So just for those who are not in the co-op world, co-ops have a bit more flexibility on housing charges. They're not bound by the rental guideline that the nonprofits are. And in answer to your question, Candice, I'm not aware of any legislation. That will be interesting if that would be enacted, but I haven't heard anything that would suggest that. And maybe someone from CHF Canada or one of the federations has more intel on that, and they might weigh in on the chat here. Co-ops are refusing to give back clients subsidy programs after they lost income. Okay, co-ops, I don't understand Diana's question. Co-ops are refusing to give back clients. I'm sorry, I don't understand. I think maybe I think we've covered all of the questions then. Unless anyone has any other burning ones, we're a bit short. Oh, Marianne is telling us, no legislation rebudgets. However, the difficulty is in getting members to approve the budget and housing charge increase. Virtual meetings are now allowed, but difficult to do. Yes, Claudia is going to talk more about that in the presentation she does in a couple of weeks. But for those who are not aware, it is now possible to have a virtual meeting using video conference. But of course, the challenge is, as somebody has pointed out, not everyone has internet access. So it may be a challenge to get a budget passed. And so therefore, many co-ops, I'm sure, will be taking advantage of the now allowed delay for AGMs, which will mean the current budget will stay, I guess, until a new one is in place. Okay, somebody's clarifying Diana's question. I think Diana means that those who lost the subsidy for whatever reason and our market want their subsidy back, but some service managers are saying no. I haven't encountered that, so I don't know I can see how that might happen. I mean, in some cases, you know, subsidies not available, so you can't get blood from a stone. I'm sure any of the co-ops where the co-ops, that is, where they've had emergency subsidy, that's all been exhausted completely. And then Stephen Morgan has quite rightly said, in addition to video conferencing, you can do telephone conferencing as long as everyone can hear. And that is the requirement. And that's true. It just makes it, I'm not sure whether there's a teleconference line that everyone would have access to, but you're right, there is an option. Can we have a virtual conference even if everyone does not have access, or do we just need quorum? It's my view that everyone should have an opportunity to attend an AGM. And so you'll need, I think, to ensure that there is access, because then other people are disenfranchised, right? They don't have a right to vote on things. What is your, Mayor has asked, what is your opinion on tenants and members that are requesting rent abatements because property amenities are being closed in order to comply with social distancing? That's an interesting question. I don't know what the LTB would say about it. I haven't considered it. It's a good question. Yeah. Let me think about that. Maybe we'll blog about that. Thanks for the idea. Oh, Stephen's saying Zoom has the option for both video or only telephone in the same meeting. True. Actually, that's true. Well, there's a good idea. Any other questions? We've still got a couple of minutes. And if not, going once, going twice. So we still have 65 people on the line, and I thank you very much for your attention. It's an odd way to deliver a webinar from my own office at home, but I've kind of enjoyed it. So I'll do it again. How's that? Thanks, everyone. Stay safe.